So it's 1:30. We could slowly be returning from the break. Let's see if our speakers for the next session are here. I mean, I can see they're logged on, but are you back from the break? Luciana is here. We still need Polina, Arina, Małgorzata.
Я здесь.
Wonderful. Okay. Three people
here too.
Here. Wonderful. So we're opening our 8th session, Controversies of Modern Law and Religion. Our first speaker is Polina Sergeevna Korobova from the National Research University High School of Economics in St. Petersburg, their Faculty of Law, and her subject is History of Protection of the Rights of Believers in Russian Legislation. Polina, go ahead.
Hello. I want to tell you about the history of the legal status of believers in history of Russia. Of particular interest is the change of in the position of believers in Russia from the end of the 19th century to the present time, because this relatively short historical period was very contradictory. I choose this topic because it seems interesting to me to trace how modern Russia came to the current state of religion and believers. Over the past century, Russia has undergone major changes in different periods of a seemingly small period. The country had a different territory, different political regime and form of government, and accordingly different ideology and values. In the face of such serious changes, the change in the position of a judge also turns out to be significant. It is important to trace the changes that have occurred in the legal status of a church and religion since the time of Russian Empire. In Russian Empire, a religion was one of the fundamental values, and the period of USSR can be called the most difficult period of religion in Russia. And the next period is the period of modern post-Soviet Russia, in which after the collapse of the Soviet Union, religion took its important role in society again. This observation will help us to understand how religion took its current position and why in secular states, such as Russian Federation now, and Sultan, the feeling of believers was criminalized, and how legislation of protection of rights of believers changed over time. Since freedom of religion is a basic right and the spread of religions isn't limited by the borders of states, the protection of religious rights is carried out on international level of law. Freedom of religion is enshrined in Article 18 of the Universal Declaration of Human Rights. The same right is detailed in the International Covenant of Civil and Political Rights. At the same time, because of secularization of states and decrease in the number of believers in both religious and secular states, while realizing the importance of religion in society, states began to take additional measures to protect religion as a common value and protect the rights of believers on a national legislation level. Some countries that have stopped protecting religion at the state level for some reasons have started doing it again, creating a legal institution to protect the rights of believers virtually from scratch. Throughout the existence of the Russian Empire, religion was one of the main social values for unifying and relying people. Although the position of religion in society had been transformed over time, obviously, religion has been an important social institution throughout the history of Russia, but we will consider the change in the position and legal regulation of church and religion from the beginning of the 20th century to the present day. Firstly, we should briefly review the history of religion prior to the 20th century. Orthodoxy is the main religion of Russia for many centuries. Russia has been inseparable from it since the time of the baptism of Russia in 10th century. Then baptism played a unifying role and became an instrument for formation of statehood. Despite several church reforms that took place over the centuries of Russian history, the church remained inseparable from the state. Russian monarchs were crowned by means of Orthodox ceremony. For them, Orthodox confession was obligatory, and the Russian Empire was proclaimed by Peter I, and the head of the state began to bear the title of defender of the church. It should be noted that the monarch controlled the Russian Orthodox Church, which has had the status of a state one. There were certain religious restrictions. For example, until 1073, Orthodox people were forbidden to marry non-Orthodox people, and then permission was given. Permission to enter such marriages was given subject to on conditions for observing Orthodox values and raising children from such marriage in the Orthodox faith. At the same time, in general, freedom of religion was declared. This freedom was very conditional. First of all, the state used religion to solve national and political problems. This is evidenced by several stories about the forcible conversion of certain groups of people to Orthodoxy. For example, the forced conversion to Christianity of the Tatars in order to strengthen statehood. At the same time, some people converted to Orthodoxy, in fact, continued to adhere to their religions, and the law forbade them to practice their religions. Some of them existed outside the something like legal field. They couldn't legally register families. The civil status of representatives of these religious movements wasn't entered in registration books, which made them less protected group. Secondly, until 1093, living Orthodoxy was a crime that entailed rather severe punishment up to 10 years in hard labor. Based on these facts, it's difficult to talk about the actual existence of the principle of freedom of religion. The situation was largely changed by the decree issued in 1095 by Emperor Nikolai II on strengthening the principles of religious tolerance. This decree allowed people to accept different faiths, live in Orthodoxy, but it didn't equalize all the confessions and our adventures, but made several changes and several steps in the legal in equalizing legal statuses of person of all confessions. According to the decree, the legal status of people of different religions from Orthodox changed significantly. Criminal and administrative responsibility for choosing a religion was abolished. Was prohibited persecution of people, discrimination and restriction on civil rights on religious grounds. Nevertheless, restrictions on changing confessions were abolished only in relation to the other Christian confessions, and it was also impossible not to belong to any confession at all. And in addition, the Russian Orthodox Church changed its exclusive dominant status, expressed as an example in the right to spiritual censorship. After that, in 1096, Criminal Code of Religious Crimes appeared, which referred to religious crimes. Some of them had really strict sanctions, and some of them was less serious. At the same time, during that period, what was fall in a religious this trend largely explains the turning point in the history of Russia and calls religious indifference one of the most important driving forces of revolutionary events. These events, as well as the confrontation that arose between the church and the monarch, are associated with the church's attempts to free itself from the power of the monarch and divide the patriarchate, and rarely considered, but they are very important for understanding why in 1917, after the revolution, the absolute majority of population quite easily abandoned religion as a value. The new government sought to replace religion as a universal ideology with the ideology of communism. At the same time, people had to continue to believe in something, so communism became something like quasi-religion. And if at first the reunification of religion took place voluntarily, with the support of propaganda, then since the 20th years of 20th century, state bodies have carried out mass arrests and persecution of clergy and religious preachers. Until 1939, the policy of eliminating organized religious life was carried out to administrative manner by state authorities. The policy of those times was very contradictory. There were, despite all these activities and restrictions, instructions on inadmissibility of offending the feelings of believers were included in the draft program of the ruling party. In addition, the story is now there is a well-known in Russia story that in 2019 the believers of one of the regions of Russia turned to Lenin and the request to allow the completion of the construction of a temple, which has been started several years before revolution, and he said, yes, you can do it. However, the period of cult treatment of the church and the use of propaganda as a weapon struggle has passed, and an open struggle against religious organizations and repressions against believers began. The period from 1932 to 1937 was called the Godless 5-year plan. In such circumstances, it's difficult to talk about any protection of rights of believers and in general about the rights of believers, but it's necessary to consider to understand the historical fact. From a legal point of view, there was a decree regulating in detail the permissible activities of religious associations. In particular, religious societies were required to register and hold general meeting only with permission with getting permission. It was forbidden to create something like mutual aid funds and cooperatives. And the next period, which turned out to be one of the most difficult periods in history, and not only for believers, was a period of repression in which one can't speak about every right of people or law. People who, for one reason or another, were declared as anti-Soviet elements were subject to repression. They included church leaders, religious activists, and clergymen. After that, the machine of repression gradually slowed down. Relations between church and the state normalized. During the Great Patriotic War, a course was taken for a state-controlled revival of the church. And after several years, authorities returned to the tightening policy towards the church, and during the period referred in history as a whole, a new anti-church campaign unfolded. And after that, in 1977, a new constitution was adopted. On one hand, it declared the equality of citizens regardless of inter alia due to religion, but it also allowed to have such subjects in university as a scientific atheism. It was necessary taught in educational institutions. Even though over time the pressure of the church weakened, only in 19th years of the previous century was adopted the law on freedom of consequence and religions and organizations. Among the reasons for how the attitude of the state towards the church has changed is the resistance of religious people during the anti-religious campaigns of previous years, in particular the emergence of different confessions of associations of religious people. In addition, the persecution of certain previously little-known religious groups attracted more attention than to their and they. After that, it was a new constitution and a new criminal code. It changed a lot. It got new articles, and the I'm sorry. The present problem is that new articles in criminal code doesn't have a really understandable. I'm sorry, 1 minute, please. I can't translate it.
If there's a problem with some phrase or something, feel free to say it in Russian, and we'll try to translate.
Спасибо большое. В общем, состав статьи очень неконкретный, нет конкретных критериев.
So the new article of the criminal code was very abstract, and there are no concrete criteria for its application.
Yes, thank you. New articles are more laconic, but there are no strict criteria, so it has some problems. Global changes and in legislation in aspect of protecting the rights of believers and related law enforcement practice took in 2013, the disposition has become weaker and the sanction has become stricter. It should be noted the historical context in which these changes took place. In 2012, the Russian protest group Pussy Riot held a political performance, dancing in one of the country's main temples. They condemned the fusion of the church with the state, with the secular state of the secular position of the state, enshrined in the constitution. The case attracted wide attention of the world community because, contrary to legal practice and the principle of compliance of punishment with the social danger of a crime, three participants in the performance were charged with hooliganism based on religious hatred and sentenced to 2 years in imprisonment each other. This even sparked several protests and strikes, as well as widespread criticism, as the restriction of right to expression was disproportionately strong. This violation will later be established by European Court of Human Rights. However, the authorities didn't heed the protests and worldwide support of activism and made changes in legislation. As I told, sanctions became stricter. 1 second. It should be noted that representatives of the church themselves, those feelings should be protected by the article. The article of protection of feelings of believers. Also expressed dissatisfaction with the changes to the article. They said that God can't be mocked, and also that the Lord protects their feelings. And there is a very strange practice of using of this article in Russian law, but I don't think it's really relevant to topic of conference. So in conclusion, I want to say that disputes around the current legislation and law enforcement practice of protecting the rights of believers don't stop, and this is quite justified. The protected object has not yet been established, as well as concept of believer. There is still no sufficient justification for protecting the feelings of a certain identified group of believers under the conditions of existence of the principle of the secular state of Russian Federation, as well as equality of people regardless of their attitude to religion. And that's all, I think.
Thank you very much, Polina. We are moving on to our second speaker, that is Małgorzata Biszczanik from the University of Warsaw, Faculty of Law and Administration, and the subject of her paper is state funding of churches and religious associations appropriate?
Yes, hello. I will try to share the screen so you see the presentation, how it works.
Okay.
Does it work? Okay, I think it works.
Let's just
Okay.
wait a minute. Yes, we can see it.
Okay, lovely. Thank you very much for the possibility to speak at the conference on the topic that I would like to speak about. This is the question whether the state funding of churches and religious associations are appropriate. Maybe I would just say some things about myself. I'm Małgorzata Biszczanik. I am a student at the Faculty of Law Administration at the University of Warsaw. We had one student or two from the University of Warsaw, which who also spoke about these topics. So I'm the third one that will be from the Poland. Okay, we all know that, maybe I will just stay on the first slide. We all live in the countries that have something in common with churches. We know that there are various forms of financing churches and religious associations in Europe, around the world, in the USA, or in other countries around the world. These financing relations depend really on the state-church relations in the given country, also on the history of the states, and also on the traditions that the individual state has. The starting point for the presentation, and just to speak about taxes and church finances, is what is the relationship between the state and the church, which is really the institutionalized form of a given religion. The original beliefs of the people that inhabited pre-Christian Europe were for the most part displaced by the Christianity in very early periods, and those relations in the Christianity, pre-Christian Europe, were between the state and the church, and they have not yet developed on their basis. In this pre-Christian Europe that I have already talked about, we had few main topics that we need to speak about. We have demonism. This is, I think you should hear about this. This is a system which is characterized by the identity of religious and state authority. In the eastern version of Europe, we had the hierarchy, which was the idea that assumed the primacy of the religious element over the political. Between the monism and hierarchy, we had something that was a dominance of the political power. And this dominance of the political power was seen in the Western version of the pre-Christian Europe. It was very much exemplified by the cult of the Roman emperor, so by the Roman law, which we talked about on the first day of the conference. However, even though the monism and hierarchy have very long tradition, it's quite hard and it's quite difficult to determine which of the two elements was in fact dominant. We can trace the steps of monism and hierarchy to the early ages. This is the 1330. I'm so sorry, 313. We all know that this date was something with the Edict of Milan. This edict was introduced by Emperor Constantine, and it established religious freedom within the Roman Empire. But with this edict, the religious dualism was into force. However, when Constantine died, his successors claimed the right to supervise and control the church and all dogmas, even dogmas in the church. So it was something that distracted and really undeveloped the dualism between church and state. In Western Europe, we had something like the fall of Roman Western Empire. With the fall, the political situation favored dualism. However, with time, this homogeneous Roman Empire was replaced with barbarian states. We all know that barbarian states very shortly and very fast recycled many solutions from Roman law. And with time, they often adopted the Christian faith. So it was also stepping into dualism rather than monism. On the other hand, we had the Christian church that neither had the legal prerequisites nor the possibility to impose its supreme authority over the new states. So as a result, we had something like sacerdotium, it was in Latin for the spiritual power of the Pope, which coexisted with the imperium. This is the power of the rulers of states. What happened that we had taxes so fast, and that we have taxes right now in countries in Europe? Over the centuries, states have financed the activities of churches in various ways. At the beginning, church, which was, I would just speak right now about the Middle Ages. The church state, which was established in Middle Ages as the main center of the Catholic Church, had really a complex system of financing itself. It consisted of secular and ecclesiastical revenues. One of the most known taxes, as I can say, was tithing. And there is a question whether they were voluntary or compulsory. Tithing were voluntary, Levi, so but at the beginning, and they survived in the Frankish monarchy. However, we had the role of Galician synods in the 6th century, which who transformed it into the compulsory Levi on the church. Then we had the Charlemagne, who enforced tithing compulsorily, both in the territories of the Frankish monarchy and also in the lands that he conquered. This revenues and tithing was adopted later by many countries that emerged after the collapse of the Frankish monarchy, and also in time in Poland. Because we had some systems of financing churches which are different in many countries of Europe. I just focus on 3 countries: Poland, Germany, and France. In Poland, this institution of tithes appeared practically with the establishment of the state. So already at the beginning, mostly because of the influence of the Roman law, and also because of the influence of other countries. In Poland, at the beginning, was one historic and few churches in Poland. So Polish rulers transferred part of the income to the church directly. However, with time, so this tithing lost its character, and they were not compulsory, and they were not transferred. They were not transferred directly from the income of the state, but they became a fee, which was charged by the whole population. And with time, the church was has become a powerful landowner, and with this, it derived income from its estates. We need to move right now to the 20th century. I know it's that we move a few centuries, but in 20th century, we had the situation with the communism authorities, especially in the years 1947, 1956, who launched an attack on the Catholic Church, its structures and people. And the general aim of the communists was to push Catholicism to the edges of the society and the public life, so that it wouldn't be as important as it was before. And with this, the taxes were not sufficient, and the church in the communist era was not taxed, I can say. But right now, the taxes are really the same as at the beginning, so we can say that history comes full circle. In France, the situation is different because of the secular state model, and because that the French model is a hostile separation between the state and church, contradiction to what happens in the denominational state model. In France, we had something big, as I can say, with the French Revolution, because the new rulers of the French Revolution criticized really the church from the worldview position that they were the opponent of a liberal ideology, and that the church is really a close ally of absolute monarchy. So it was something that society didn't want. And with French Revolution, and so big an event changed what French people and French society and the whole France thinks about the church and its taxation. The priority right now was always to all French people was the freedoms. The freedoms that in aspects including religion comes first. However, the religion is not the most important part of the freedoms. We had something in the French history that changed. This is the Jacobin government, the Paris Commune, with the eradication of the church from the public sphere. And the church was really intensified, and the eradication really intensified in the time of the Jacobin government. With time, we had 1905 with its French constitution, in which the state created a special law and associations, and the church became one of those associations, the cult association. And the aim of this law was really to banish the church from the public life. And what happened was not as good for the Europe and French as they thought to be. This is because it really occurred in a break of relations between France and the Holy See. And only in the 1920s, these relations really improved. But it happened to be 15 years of really the war between church and state. In the same year, we had the law on the separation of church and state, which was passed in the government. With this act, the church property was considered to be state property. So we had, again, the small war between state and church in France, because the religious associations, this is also the church, really had limited rights regarding churches, seminars or parish houses. At the same time, the French people in the French society, France, was obliged to pay for the insurance of the church buildings and priests. So it was not good for both sides. Right now, the French Constitution of 1958 includes the principle of laïcism. So, and the situation between church and country is already stable. The model that we see in Europe is German model. The German situation was slightly different from what we see in Poland or in France, because already in the 19th century, maybe I can say it different, because we all know that Germany took some sources from Roman law. And to the 19th century, the Roman law was really the main topic of interest in Germany, and in relation between church and state. In the 19th century, however, the German legislation moved away from the principle cuius regio, eius religio, which was developed after the religious wars. Since 1815, Germany has really been an interdenominational state. However, Germany introduced the principle of religious freedom rather than privileging a few major religions, which, as we can see in the history of Poland, was not good. However, even though this principle of religious tolerance was introduced, we had tensions between Catholic Church and Protestant Church, which culminated in Bismarck's Kulturkampf. I don't have time to speak about this, but it's quite interesting topic. So if everybody were interested in the Kulturkampf policy, I really would be really happy to say some things about this later, or just give some books. Nevertheless, Germany had something that we can say of system of church tax. This was obligatory throughout the whole of the Union, and it was established by the Weimar Constitution of 11 August 1919. With the Constitution, the Weimar Constitution, which in this sense, in this presentation, is really the most important constitution, the church became a kind of autonomous entity, and it was able to negotiate with the state about taxes, about marriage acts, and other things. And the current German constitution, because of the prospective Weimar Constitution, also incorporated some things from taxes. about sexus to the law that we have today in Germany. In short, because we don't have so much time, the financing of churches right now is based on the Grundgesetz and is based on the church tax and state aid. Indirectly, the Grundgesetz measures the income of churches from the property. So we have pretty the same situation as it was in France in 1905. However, the state is not obliged to pay for the properties. And if I remember correctly, the Grundgesetz also says that church, not church as the Catholic Church, but all churches derive income from collections and economic activities, which is really something new in Europe. And what are the conclusions? Because I don't have so much time. The presentation was to show you, as your audience, that we have very different perspectives on church-state model, and that some states recognize churches as the legal personality, some states not. That the history really and traditions of the state really gives the idea what church in this sense is. And there's a question that I said at the beginning: is it really appropriate to finance churches and religious associations from the state budget? As we can see from the history, the financing churches and religious associations from the state budgets, rather than giving peace, it just gives wars. And this is something that no society in Europe, the democratic society, wants. Thank you very much.
Thank you very much, Małgorzata. We are moving on to our third speaker in this session. That is Luciana Aleixo from the University of Lisbon Faculty of Law. Luciana will be talking about the importance of canon law in the framing of the principle of favor sexus. Please go ahead.
Good afternoon. I want to thank you for the conference, the organizers, for the interest in my work, which I'll be presenting today. As you said, the influence of canon law in the principle of favor sexus. I'm sorry, I'm going to read because my English is a little rusty. It's widely agreed that in the criminal law of the old regime in Western Europe, several circumstances were interpreted as attenuating the gravity of the criminal action. In other words, the offender's intention, the quality of his reasons, his judgment, the facts that he could present to justify himself as his age, his social condition, and his sex were for the judges only several circumstances whose overall examination allowed to define the measure of the penalty. Thereby, the offender's responsibility was measured in part in view of those circumstances that today have received a general and systematic treatment in the law. The judges did not distinguish the problems of responsibility from all the other circumstances that they should assess. All of this has consequences for women. For some jurists of the 16th century, sex is considered a cause of non-culpability. The natural fragility of the woman's spirit and will, as well as her inability to withstand the rigor of certain penalties, will give rise a priori to a favored treatment. The judge will appreciate the guilt of women more benignly, especially when the offense is justified by a positive crime, not a natural or divine. Criminal law is a later and a poorer branch of the dogmatics of common law. In Roman law itself, criminal matters have always been dealt with outside the ordinary judicial order, either by special political courts or by magistrates acting as if administratively. The fact that this form of extraordinary cognition gives the judge discretion, extensive space, further delayed the establishment of dogmatic principles in this area. This poverty of Romanistic sources in relation to an autonomous concept of crime and criminal law also explains why criminal law was late discipline in the evolution in common law. In 6th century, mainly with Tiberio Deciano, but also with Menóquio, Júlio Claro, Antônio Mateus, and Próspero Farinácio. According to the interpretation of rules formulated in Roman law, Farinácio argues in favor of less punishment of women due to their less rationality. In his works, Praxis et Theorica Criminalis, which has an enormous influence on modern legal culture, the concept of fragility sexus appears as the foundation of a reduced female imputability. The exceptions to the rule are, first, in crimes considered serious, adultery, parricide, and crimes that endanger the security of the state or community, such as heresy, magic, and witchcraft. And second, if the imputed women have shown a particular cunning, the principle valid for the punishment of minors that malice provides for age could be applied by analogy. Tirakellos was the first to find a new emphasis on the relative objects of the penalty, and among these, that of correction. It tries to expose and classify the general causes of exclusion and mitigation of the penalty, which are often mere considerations about the measure of the penalty or procedural legal points of view for the granting of grace. Many of them achieve the same essence and structure as the concept of crime. Anyway, what interests is the result, exclusion or mitigation of the penalty, and the elements of the offense must appear secondarily to substantiate the result. The jurist, in his main work, expressed similar distrust to the rationality of women. In invoking the authority of ancient philosophers, it is questioned whether the women belong to the group of rational or brute animals. It will sustain less punishment because of the weakness of her spirit, intelligence, and rationality. Here, intellectual frailty is common to use, old way, age, and the female gender that legitimizes the abolition or mitigation of punishment as opposed to the mitigations provided for by modern rights, which are determined more by physical weakness than intellectual weakness. The foundation lies in his interpretations of Roman and canonical legal sources. See case 9 of the Poenis Temperantes. Thus, to the extent that men are endowed with more reason than women, being able to mainly resist incitement or to addictions, or as theologian says, being able to resist temptations, it's fair to punish women with more leniency. Later, the penalist Jus Damonher takes up the same idea. The woman has an hesitant and fragile judgment. They lie hesitant and fragile, uncertain. For this reason, forgiveness should be bestowed upon when you stray, as long as you are not aggressive, not malicious, not hardened to evil. Jus, after enunciating causes that focus exclusively on guilt, lists those that mitigate the penalty and among them points out the fragility of sex. It also maintains that women should be punished less severely than men as long as they belong to the role of positive law and not natural or people. Regarding the main cause of the delinquency, Jews attributes to the guilt, passions, and the vices of men. All the crimes that reign in society extract their source from the lightness and inconstancy of the human spirit, in the lack of education and corruption of the heart, and even from contempt from religions and laws, from which arise illness, revenge, ambition, and other disorders of life are born. Anyway, as seen in the theories of some of the main treatises of the 16th century, female inferiority did not only translate into dependence on family life, contractual and matrimonial incapacity, but also conferred a privileged position when it transgressed the laws. Modernity disseminated this ancient concept of inferiority of the female sex, broadening and generalizing its meaning, and the jurisprudence drew its own consequences. We can say that, in general, the opinion of modern jurists was based mainly on three feminine aspects: less dignity, fragility, and lasciviousness. The first, responsible for subjecting women to the tutelage of men, was based on the natural and biological foundations of Aristotle, Plato, and St. Thomas d'Aquino, and mainly on the plurality of justifications of the judicial tradition, nature, history of creation, and original sin. The second, I'm too much of my time?
You can go on a few more minutes.
Okay, thank you. The second, in addition to equating women with the rustic and the minors by classifying them as naturally ignorant, consider them fragile, intellectually and physically, due to this impotence to impose themselves on the masculine. The latter served as a pretext for juries to claim immodesty, lust, and consequently the weakness of women. The doctrinal construction is fundamental to understand how sex can be seen as an adjective in the assessment of women's criminal responsibility, and ultimately in determining the penalty to be suffered. The image of the woman as a fragile being is an old representation that has been reflected in different levels of European societies. On the religious plane, the woman gives into temptation and evil, and in law, under the expression of imbecilitas, infirmitas, and fragilitas sexes. Discussions about law in the Middle Ages necessarily involve canon law, the rebirth and discovery of Roman law, federal law, and the emergence of universities. In this way, reference to the Bible and the priests of the church are combined in the medieval texts, alongside with in the classical works of legal and political philosophy, and increasingly from the revival of Roman law, also the Byzantine text studies in European university. In this context, the emergence and expansion of universities caused an increase in interest in law, focus on studies in Roman law and canon law, and always starting from fundamental texts, mainly the Decrees and the Decree of Gratiano in the canon scope. We must go back to the origins of Christianity to understand the position of theologians and canonists. First of all, I'd like to say that it's not easy to talk about women, the status of women in medieval canon law, because it's very complex and very ambiguous. And the theme is very broad. So I'll just make a few brief considerations to conclude. According to Christ's principles on the human person, redemption and holiness, women are absolutely equal to men. No gospel text establishes an equality between men and women, the Gospel, according to John, testify that Christ has an egalitarian attitude because he treats women as men. His behavior towards adulterous women, and especially the Samaritan women, clearly proves it. But apostles were men of their time and environment. Jewish conception of women stands out. It was especially in this exercise of public worship that the woman inferiority was manifested. The law to be excluded from liturgical functions, which were reserved to men. As a result of doctrinal elaboration based on the principles of Genesis, the epistles of São Paulo, and later in the works of Tertulliano, St. Augustine, San Jerónimo, Graciano, and Santa Tomás de Aquino, they insisted in negative aspects, which others will also value in some positive measure, but dualism still exists in all of them. I will tell in my paper about all these examples in the Decree of Gratian and in Gregorius' decree too. But to conclude, the theologians of the Middle Ages were no more favored to women than these first ancient theologians had been. Undoubtedly, they put more form into this point, but they will not give more pride to the woman. They will use the same old arguments, the distinctions and the subtleties of the scholar's philosophy, and we will ensure that the woman stay with this inferiority position. I would like to tell more, but the time is finished. So thank you all, and if you have any questions, I'm happy to answer.
Thank you very much, Luciana. I hope there will be questions in the discussion. And now we move on to our last speaker for this panel, Arina Alexandrovna Sasova from the Belarusian State Economic University Faculty of Law, and her subject is Some Religious and Legal Rules on Assisted Reproductive Technologies, Probability of Convergence in the Republic of Belarus. Arina, the floor is yours. Okay, so while Arina tries to fix her problem, does maybe someone have a question for any of the first three speakers? We can fill up the wait with some discussion. If not, I will try to ask a brief question to Luciana. I'm not an expert on your subject, but I've been doing some research on criminal law, and generally in the 19th century, for example, and I'm talking about authors that have nothing to do with the church, just worldly legal sources. But there's this contrasting attitude that generally women are treated more leniently because of their sex in criminal law, but when a woman commits some sort of more severe crime, particularly something very violent, then that is treated as absolutely abhorrent. She's treated as a monster, completely unfeminine, and so on. So is something similar present in the canon law authors?
Yes, I was a little confused in the end of my presentation, but it was supposed to explain that normally the sexual crimes or the crimes that are related to honesty, honor, and these moral customs are less forgivable for the judges, and this has its roots on the canon law. in my research is not in canon law either. It's in Portuguese law of the ancient regime. But what I found is that we can search for these characteristics in the bottom. The woman that is Christian and is honest, is from a good family and has a good behavior, they will have a different treatment from the prostitutes or the woman that has this temperation of this strong personality. And the crimes also will have a diverse consideration. We can, in my research, we separated the people and the crimes, and the crimes has to be has a correlation with the sins in the church, and it's separated from the divinal, the natural, and the positive crimes, the positive law. The divinal law and the crimes in the divinal law, they have another weight too. It's different from the crimes like robbery and bigamy, for example. But it's mostly relation to the sexual conduct and moral conduct. But this is in the bottom, and I made a research from a little bit from the Roman law, and there is some differentiation, but mostly is that there is multiple variables.
Yes.
I don't know if I was
Thank you.
clear. I can't find the words.
Yes, I understood you. Don't worry. Let's
Okay.
see, Arina, have you managed anything? We still don't hear you. I can see you're unmuted, but there's still nothing. Could you maybe try to leave the meeting and enter once again? Maybe something bugged up. Maybe if you log on again, it will work. So she will try. Does anyone have any more questions in the meantime, maybe? Sophia has a question. Go ahead.
I have a question for Luciana as well. First of all, I would like to say that you have a very interesting topic of your research. I really liked it. And I have two questions. The first is, we saw that there was some non-equality between man and a woman. So I'm wondering, what is your opinion? Who was more affected by it? The woman whose dignity was degraded, or the man who had more punishment for the same crimes? And the second question I have is, you mentioned that you are researching old Portuguese law. Do you know of any abuses of such rules in your history, that perhaps males used females to do their crimes so they would be punished less or something like that?
Yes. Thank you very much, Sophia, for the questions. I'm happy to discuss it. So I will investigate the sentences, the decisions of the judges. I not yet got there. I'm only in doctrine and legislation in Portuguese law. But here in the ancient regime, we have a principle that it's the arbitrary way of deciding. The judges, they had immense freedom to decide, and they don't have the obligation to fundament, to bring a large fundament of their decisions. So in the search, in my project, we find that there is a lot of women's, a lot. We can't say about one woman in specific because it depends of a lot of characteristics and circumstances. So the decisions, a lot of times, it's not coherent. Some women they had the luck or the advantage to be absolved, and others less, not. So, but normally in the women with a good reputation, they was given a pardon, but it's not a very it's not very certain. It's very there is a lot of sentence and judges and positions that there is no a great majority in this case. And I think in criminal law, women receive this treatment that was better than men in some cases, and sometimes I think it was one great advantage of the sex, but the arguments are terrible because we are not constant, we don't have the rationality that they had, but the result, in my opinion, was favorable, but it was only for a period when we had the egalitarian principles of the liberals, Beccaria, Filangieri, and other authors. This starts to end. I don't know if I answered, but I will hope to answer better in my paper. Thank you.
Thank you. It was a nice answer, and congratulations once more on a very interesting topic.
Thank you very much. Just one moment. I have my advisor, Professora Silvia Alves. She has an article about infirmitas, levitas, and fragilitas sex that explain it all perfectly. If you want to read it, it's a good indication.
Thank you. If you could type it in the chat, the title, so I can find it.
Okay. I'll put in the chat. Thank you.
Arina is trying to log on from her phone.
Do you hear me now?
Yes, it's a little quiet, but we hear you.
Oh, sorry. I don't know what's happened, but I'm so sorry for my technical problem.
At least we managed. Now, can you share your presentation that way, or do you need me to share it?
I can't present my presentation because it's only
it's on the computer. Okay, I'll start sharing it now. Just a moment.
Thank you.
So you'll just tell me when to turn the slides.
Okay.
Does everyone see it?
Yes, we see.
Wonderful. I'll just put it full screen. Go ahead.
Thank you. So first of all, I want to greet all of the participants of this conference and say that it's a big pleasure for me to be a part of it. My name is Sasova Arina Alexandrovna, and I'm a student of the Belarusian State Economic University. And I want to talk about some religious and legal rules in assisted reproductive technologies. Next slide, please. One of the most serious problems of mankind nowadays is infertility. According to the World Health Organization, there are about 48.5 million infertile couples in the world. Of these, 19.2 have difficulties with the birth of their first child. For many people of childbearing age, the inability to have children puts the creation of a full-fledged family at risk. Modern advances in medicine allow families to have their baby through assisted reproductive technologies. Next, please. The first work, which served as the beginning of assisted reproductive technologies as a branch of medicine, dates back to the 19th century, when in 1890s, Dr. Walter Heath reported on the successful transfer of embryos from one animal to another with subsequent birth of viable offspring. In 1934, Pincus and Ensman published an article on the possibility of mammalian egg development outside the body, which was an important step in vitro fertilization method. In 1978, Robert Edwards and Patrick Steptoe first achieved artificial insemination in a woman, and they are considered the founders of the modern in vitro fertilization method. Next slide, please. The history of the origin of surrogacy goes back several thousand years, but initially this method was very different from its modern method. In some countries, for example, in ancient Greece, if a woman could not get pregnant, it was considered possible to find an heir by turning to a more fertile woman who gave the child after birth to an infertile couple. The modern method, when a surrogate mother is not an egg donor and the child she is carrying has no genetic relationship with her, began to be used only after 7 years after the successful in vitro fertilization method in 1985. Next slide. According to the glossary on assisted reproductive technologies terminology approved on the 5th of November in 2009 by the International Committee for Monitoring on Assisted Reproductive Technology and the World Health Organization, assisted reproductive technology is all treatments or procedures that include the in vitro handling of both human oocytes and sperm or embryos for the purpose of establishing a pregnancy. Currently, more than 10 different types of assisted reproductive technologies are used in world practice, among which the most common are the in vitro fertilization and surrogacy. And next, please. Religious factors have an impact on the regulation of public relations in the field of assisted reproductive technologies. Religion as a form of primary social regulation is unshakable in traditional legal system because it provides a person with a certain set of guidelines which are often based on the external values of conscience and goodness, and they are often intertwined with the principles of law. In matters of assisted reproductive technologies, religion has a negative opinion because it considers these procedures unnatural. Next slide. And one of the reasons for the negative attitude of religion towards assisted reproductive technologies is the killing of extra embryos. Next. So the Orthodox religion allows for artificial insemination if certain rules are observed. According to Article 12, Fundamentals of the Social Concept, the Church considers artificial insemination with the husband's sex cells to be an acceptable mean for medical care for childless spouses. If it's not accompanied by the destruction of fertilized eggs. Currently, the modern in vitro fertilization method is carried out in stimulated cycles, where many eggs are taken from a woman. Consequently, in the hands of the embryologists, there are many human embryos, some of which he transfers to a woman, while others should be destroyed or frozen. Orthodox anthropology claims that a person's personality appears from the moment a person is conceived, and any manipulation of embryos that initially leads to their death is murder. Next slide, please. Islam evaluates these acts differently. The Islamic world gives permission for in vitro fertilization if a man and a woman are in an official and spiritual marriage. According to the teachings of Islam, the human embryo is humanized only on the 40th or 42nd day from conception, and until that moment, the embryo has no human status in the eyes of Islamic theologians. As a result of this circumstance, the Muslim world doesn't see any ethical problems associated with the destruction of extra embryos during in vitro fertilization. Next, in order to overcome this problem in Christianity, in our opinion regarding the application of the in vitro fertilization method, an additional limitation should be established in the legislation of states, including the Republic of Belarus. The number of created embryos cannot exceed that which can be transferred in one IVF cycle. This legislative innovation is aimed at solving the problem of extra embryos in accordance with religious norms. Next slide. Another reason that causes religious disapproval of assisted reproductive technologies is the interference of a third party in the fertilization process. Next, please. The Roman Catholic Church insists on the problematic aspect of this issue. One of the main ethical requirements of childbirth, in its opinion, is that it should be the result of the union and personal relationships of the spouses. The concept of interference in the fertilization process of third parties also implies surrogacy. The issues of surrogate motherhood are touched upon in an important document of the Russian Orthodox Church, Fundamentals of Social Concept. According to this act, surrogate motherhood, which means the bearing of a fertilized egg by a woman who after birth gave the baby to a customer, is unnatural and morally unacceptable, even in cases when it's carried out on a non-commercial basis. And this technique involves the destruction of the deep emotional and spiritual connection between the mother and the baby that is formed during pregnancy. In Islam, surrogacy is prohibited. Next slide. One of the possible ways that can contribute to solving this problem, from my point of view, is to provide an opportunity to conclude a surrogate motherhood only on gratuitous basis and only on condition that the surrogate mother is a relative of the genetic mother or woman who used the donor egg, or a relative of the spouse of the genetic mother. The relationship between the surrogate mother and the future parents of the child is a guarantee that there is no actual relationships between the surrogate mother and the future parents, and the fact that a woman is a relative suggests that she cannot be considered as a third party due to the presence of the family ties. And next slide. So, as we can see, nowadays there is a critical attitude of various religions to assisted reproductive technologies. At the same time, the reasons causing their negative opinions can be solved by including the following rules in the legislation. First of all, the number of created embryos cannot exceed that which can be transferred to one in vitro fertilization cycle. And secondly, the possibility of concluding a surrogate motherhood agreement only on gratuitous basis and only on condition that the surrogate mother is a relative, because this can help to say that it's not like a surrogate mother due to the presence of family ties. So thank you for your attention.
Thank you very much, Arina. So now I'm reopening the discussion. Are there any questions either for Arina or for any of our previous speakers in this session? So feel free to either ask them orally or type them in the chat.
I have one question for Arina.
Go ahead.
I just want to know what she thinks about right of a surrogate mother to have contact with a child, and even she has any right about child that she has give birth.
Thank you for the question. First of all, I want to say that in my country, in the Republic of Belarus, the surrogate mother can't hold the child after giving birth. So I think that this question touches a lot of ethical aspects because even when surrogate mother knows that she after birth should give this child to parents, some deep emotional and spiritual connections are formed between them, and I think the surrogate mother, when she concludes a surrogate motherhood agreement, she should understand that she can't have this connection between the baby because after birth she will give it to their parents. That's why this question is not. This question doesn't have a strict answer.
Thank you for your answer.
Thank you. Do we have any more questions? I might have a joint question for Polina and Małgorzata. We have seen some parallels, although the subjects of their papers have been different, but there are some parallels given the communist influence in the period of communist rule in both Russia and in Poland. So the joint question would be, what is your perception? Has the attitude to religion after the communist regime was abolished returned to the state before communism? So have the new laws more or less repeated what the old laws contained, or have there been any radical changes? So whichever of you wants to answer first, go ahead.
Okay, so maybe I will just begin. So as I said at the presentation, so we had the years 1947, 1956 when the communists just launched the attack on the Catholic Church, its structures and people. The result of these attacks was the whole, say, use of the power to implement the Soviet concept of the separation of state and church. This means the liquidation of Catholic associations, also the eradication of religion from schools. And we can see right now the influence that these actions had. This means that even though we have, as I can say, results of, I have a word in German, but it's, I need to translate it in Polish. Even though we have the results of service that show that the communist actions right now have nothing to do with what we perceive as the church and state. The implementation of actions in the between 1947 and even the 1980s have really a big influence on what we perceive as a religion. If I answer your question.
I think you did generally. And just as a quick reply before Polina takes over, what do you think generally about the key question of your paper? So is the state funding appropriate or not? Does it depend on the religious structure of the country? So if we see one country with a very dominant single religion, whichever that religion might be, and one that has a wide religious pluralism, would state funding be more appropriate in one than the other?
Okay, I think I do understand the question. So we have monism and dualism, as I said at the presentation, and it's quite hard to say which countries, which European countries are monistic and which are dualistic and which are laistic or which are in strong ties with the church. Because even though, for example, France is really the basic example of what a laistic state is, the Germany somehow corresponds to that subject. Poland, on the other hand, we don't really, we can't really say whether it's laistic state, whether it's a dualistic, monistic, because the perception of religion in Poland is really the main topic of discussion of society and at the universities. But so I can't really answer the question whether the strong ties with Catholic churches really corresponds to the fact that a country is either dualistic or monistic. But answering the question that I stated in the paper, when a country does and rather did have strong ties at the beginning of its existence, so those ties are no more strong. And we see this at the example of Poland, Germany, France. In Poland, because it is the example that is really easy for me to give. More than 60% of Polish society thinks that religion in schools is useless. And the Catholic religion, not for example Protestants or Islamic religion, even though Islam in Poland is really banned by the government as the idea. However, answering your question, it really depends on what the society thinks about the religion and about the church and about religious associations rather than and traditions and the history of a state rather than the relation between state and church in legal acts, for example, concordate between a country and the Holy See.
Thank you very much. Polina, so the same first half of the question was applied to you. So would you say that when the communist regime was abolished, that the legislation regarding religion returned more or less to the state before the communists, or did it adopt a completely new model?
If I understood the question correctly, in Russia laws, legislation about the rights of believers, yes, they changed. The general idea stays similar, but there are certain differences, and we must remember that now it is our situation completely, because Russia is a secular state, and now there is tendency for the fusion of the state and the church again. So legislation is something similar to the prior one, but there are some differences, and I didn't have time to tell about it in detail, but now there is new legislation on protection of believers' rights. Sometimes for several years, it was also used for some political persecution. In general, this wide vague composition of article all allows to be used very selectively, and something like that, because I told about it. Legislation is similar, but practice is different.
Okay, thank you very much. Do we have any more questions? Feel free to ask either orally or in the chat. Sophia has one more question. Go ahead.
I have a question for Małgorzata. I'm sorry if I mispronounced your name. I'm wondering, you talked about that it isn't appropriate for the state to fund the church or the religious organization, but I'm wondering, in the case of the state financing, for example, a renovation of the buildings or something like that, would that be justified? Because the buildings are also somehow cultural heritage and not only religious objects. So what is your opinion on that?
As an example of those renovating churches and state and church buildings, I can give France and the Act of 1905, because as I said at the presentation, the relation between state and the church was that the church will pay some taxes to a state, and the state will renovate the churches and other sacral buildings, and will also pay the price. However, but the 1905 was more than 100 years ago, and a lot of things changed in this time, and not only in France but also in Europe. I believe that, as you said, the churches and sacralic buildings are really the part of the history of a tradition, and we cannot really say that even though we have dualistic and laistic states, the churches and sacral buildings should not be repaired. So I believe you think so, that even though we have a laistic state, the churches and sacral buildings should be repaired as really a history and a tradition, even though the taxes are just taxes. But history is really the most important fact of our perception of society and the state. Thank you for this question. It's really interesting.
Thank you for your answer. I really agree with you. If nobody else is waiting to ask a question, I have another question for Arina. You mentioned that the question of artificial conceiving would be resolved if the surrogate mother could be a relative of the spouse of the genetic mother, if I understood correctly. So the Christian doctrine says that the child has to be a product of the man and wife. If the surrogate mother is related to the man, how is the element of a wife included? I didn't quite understand that.
If I understand your question, the childbirth should be the result only the man and the woman, and the surrogate mother can't be due to the interference, or could you repeat please the question?
If I understood you correctly, the surrogate mother can be related to the husband. Is that right?
Yes. It can be, but it's not included in the legislation. The legislation tells us that surrogate mother, it can be a woman, only the age is written in the legislation. But my idea that to make the surrogate mother only a relative, because of church and other religions says that interference can destruct the relationships between the baby and the mother due to the presence of the third party. But it's like a legislative innovation should be.
I understood you. I was just wondering about the religious answer to your proposition, because then the wife wouldn't be a part of the making of the baby, so to speak. But
Yes,
I understand what you had in mind.
yeah, I agree with you. But I think when a mother wants to have child and want to have a baby, it's maybe will be the only way to have it. And of course, yes, I agree that it's not natural when a surrogate mother gave a birth to another family. But I think that it could be extremely way for families who really wants to have their own baby.
Thank you for your answer. I understand now.
The
Great
question.
presentation.
Thank you. Do we have any more questions? If not, then let us thank all four speakers once again. Those were lovely presentations, and I hope you will send your papers for publication. And now we are concluding our 8th session, and this was the final English session, so we say goodbye to all non-Serbian speakers. Thank you all once again for participating in the conference. We'll be in touch by email regarding your certificates of participation and the publication of the papers. And now we are going to make a 10-minute break and continue at 3:15 with our final Serbian session. Thank you all very much once again.
Thank you. Goodbye.
Thank you.